My name is Barry Matthews. I'm a partner in Wilson Browne Solicitors. We have 5 offices in Northamptonshire and 1 in Leicester. We have 5 specialist departments, one of which is the private client department. I am the head of the private client department at Wilson Browne. I'm also a member of the Law Society's private client section and also a member of a specialist group called the Solicitors for the Elderly. We deal in wills, lasting powers of attorney, administration of estates, protection of assets. We have a large client database of people who have beneficiaries, children, relatives, all sorts of people who are handicapped or who do have learning disabilities. We're well experienced in dealing with them and know personally the problems that those sort of relatives can create. Lasting powers of attorney came in October 2007, replacing enduring powers of attorney. Enduring powers of attorney were very useful documents, 5 pages, relatively inexpensive. Lasting powers of attorney, however, are now 15, 16 pages, a lot more bureaucracy, but at the end of the day, lasting powers of attorney are usually almost as important as making a will. There are 2 types of lasting power of attorney, one of which is the financial one of which is the personal side of things. The financial one is extremely important because if one becomes unable to manage your own financial affairs for whatever reason, then your attorneys can step in to assist you. It doesn't mean that if you appoint somebody attorneys, they can immediately deal with your monies as they wish, not as you wish. It's a potential sharing of authority as opposed to just signing everything away. A lot of people assume that appointing their children as their attorneys means they'll never see the money again. It doesn't always happen that way, rarely happens that way. It is a very useful tool for assisting people in managing their finances. With regard to wills, it is invariably essential for people to make a will, no matter what their circumstances are. Too many people assume that everything will go to their husband or wife, or to their children or whoever, but that doesn't always happen. Wills are also very useful for the protection of assets, whether it's against the state, third parties, beneficiaries who think they should have a greater share of the action, or whatever. With a will, you can also appoint guardians, which can be very important, and you can, more importantly, decide who gets what. With disabled beneficiaries, disabled for whatever reason, it's very easy to put a share into a trust for them with whatever conditions within reason you think are advisable, and then they will have access to the trust, usually discretionary, so it can't be taken into account for means-tested purposes, but they have access to the monies in the trust, controlled by the trustees, for their benefit until the fateful day, and then it goes to perhaps other beneficiaries or charity or whoever. As part of the trio of vehicles to protect assets, the last one is the protected trust. A lot of people are concerned that their property, for which they've saved up for, paid out of taxed income, whatever, will be taken by the government to pay residential home fees or any means-tested service such as that. It is quite possible for that asset, usually the home, to be protected. Partly one can have a life interest in a will whereby, for example, the husband leaves his half to the children, with the wife, or what would be the widow, having a life interest in it, so the husband's half is protected and can't be taken into account for payment of home fees. The full protection is putting it into a protected trust, which has additional benefits. So if the property is in a protected trust, then if the former owners, so to speak, die, then one doesn't have to wait for a grant of probate to sell the property. It can be dealt with, rented out, sold, whatever, immediately, and don't have to wait 6 months or more for a grant of probate. Another benefit is that if the owners, heaven forbid, lose capacity, then appointing a receiver would take 6 to 9 months, and it's very expensive before the property can be dealt with. Or alternatively, the lasting power of attorney, unless one already has one in place, then they take about 4 to 5 months, during which time the property can't be dealt with. So protected trust has 3 benefits, one of which it saves the property from being taken for the payment of home fees, assuming that you don't go into a home for 2 years or so, and the other benefits should you die or should you lose capacity. Unfortunately, so many people don't realise the importance of having a will, lasting power of attorney and protected trust. It is usually highly advisable to have at least 2 of the 3. Usually, to be honest, all 3 will cover more or less every situation that can arise. And to be brutally frank, if you have a will, lasting power of attorney and protected trust, you have as complete peace of mind as you're likely to get, because there is very little else that one can do to assist you in dealing with problems that can arise from having handicapped, disabled friends, relatives, children, adults, and so on. Although I said that having a will, lasting power of attorney and protected trust is almost a must, if you have one of the 3, then we would offer to look at whatever you have to see that it is up to date, that it works, and it covers what your objectives are. Quite a lot of our clients have either a will, a lasting power of attorney, or some sort of trust, which is all well and good, but unfortunately over the years the law has moved on, and they can find that whichever document they have, or whichever mix of documents they have, aren't necessarily up to date. They don't necessarily matrix with each other, and thus their effectiveness can be severely reduced. A quick 5, 10, 15-minute chat, we will be able to say whether or not they are still effective, because there's nothing worse thinking that you have a document or set of documents which do the trick, and they don't.
Great.
At Wilson Browne, and perhaps other firms as well, we offer a no-charge review of will, lasting powers of attorney, trusts, to make sure that the client's requirements are still the same and the law hasn't changed. That's a service we offer for all our clients, usually on a 5-yearly review unless something happens in the interim. Because of the specialist nature of this work, Wilson Browne have a specialist team which carry out a lot of it. We can deal with clients all over the country, because we do have clients all over the country. If a client wishes to, or potential client wishes to use a solicitor near their home, then absolutely fine, quite often the thing to do, but ensure that that person has the relevant specialist expertise to carry out the work. There is a group, as I mentioned before, called Solicitors for the Elderly, which is one of a specialist group, and they know what they're doing. It's always dangerous, I'm afraid to say, to ask somebody who's not a specialist to deal with something which is extremely complex.